something I heard pretty recently was that these 7 countries weren't randomly selected by President Trump, and that they were actually 7 countries that were identified by the Obama administration in a prior executive order, which, and I'm going to butcher this, but basically disallowed folks who came from these 7 countries and immigrated to other European countries and then were trying to obtain visas to come to the U.S. They put those folks on high alert. So folks from those 7 countries who were going to, say, France and then leaving France and coming to the United States. They put those folks on high alert. And so the 7 countries, what I heard, I don't know if it's true or not, is that they were identified by the Obama administration, which I feel like if it were true, would be a great argument for the Trump administration.
Right. And which is why it is a talking point that the Trump administration has been repeating. And it's not true. I mean, that is, it's true and it's not true. Let me give the true version. Peter can correct me if I don't get it wrong, if I don't get it right. But this is my understanding. That is, the 7 countries were identified in prior, in 2 events that happened in the Obama administration. 4 of them were identified in a statute that was enacted as a rider. So it wasn't, that is, Congress identified these 4 countries, 4 of the countries, through this rider, and then the Obama administration added 3 others through executive action. But the countries, as they were used in these 2 programs, were for a visa waiver program, somewhere along the lines that you're describing, but I don't think it's exactly right. And this is the point that I'm not 95% sure, and if I'm wrong, I'll be corrected. That is, people who come into the country who are citizens of countries that don't normally have to get visas, that is, they have a waiver of the visa, it excluded them from the visa waiver. That is, if you were an EU citizen and you had visited one of these 7 countries.
Am I getting this right? So far?
Yes. Yeah, then you would have to get a visa. That is, the visa waiver wouldn't apply to you if you visited one of these countries. The problem with using that as the source for the executive order is there was no finding by the administration or by Congress that these 7 countries are uniquely dangerous and should be treated differently from all other people. And the suggestion was people who visited there might be more dangerous than others, and therefore their visas, they should have to get a visa. But to use it now to exclude citizens from the countries completely, to say we're not going to let you enter the country at all until we improve our vetting and start asking you questions to exclude you, or we'll exclude you unless you can show that you love America, they say to the citizens of the country, is totally unsupported from the history of how those countries got designated in the first place. That is, there's some, they found a way in the law to, so they wouldn't say, we are picking these 7 countries, right? So they could still say, we picked these countries from some neutral process that was already on the statute books. We didn't identify them. The Obama people did. But it's not, they were picked by Congress and by the Obama administration for a completely different purpose than this.
I'll push back a little bit and suggest in the following way. I think Jared is largely right about the law.
See, 95%, that's just what I'm always aiming for.
That's very good.
Was it A?
What I push back on is not so much the law, or the facts for that matter, as the interpretation. So this came out of Congress's conviction that we were letting people in without due care. Right? So it was really a variant, sort of precursor of some of the concerns that are raised in a much more exaggerated way, and I think a counterproductive way, by now President Trump. The administration reacted to the delegated power that Congress had given it in the statute, which is 8 U.S.C. 1187 A12. And that statute empowered the administration to designate certain areas of concern. That was the language in the statute, areas of concern. The administration looked at a number of places around the world, and considering foreign policy issues and counterterrorism issues, they settled on 5 countries, along with Syria and Iraq, that were expressly named by Congress in the statute. And those 5 countries include Iran, which is a state sponsor of terrorism, recognized and accepted by Congress, and countries like Yemen and the Sudan. In those countries, we have armed conflicts going on, and in Sudan we have a genocide that's really been going on for well over a decade. Millions of people have died in those conflicts. The administration, I think, felt that if people have gone to those areas, even if they're from visa waiver countries like the United Kingdom or France, we want to inquire further. One reason you want to inquire further in visa cases, in refugee cases, is because information is very difficult to get when you're thinking about matters that occur abroad. That problem of a lack of information is a huge problem for applicants for refugee status or applicants for asylum, as immigration lawyers in this room know. And indeed, the Supreme Court has reacted to that by saying that the standard of proof in asylum cases, rather than being a preponderance of the evidence, you got to prove by 50.1% that you have a well-founded fear of persecution, if you go back to your country of origin. The Supreme Court has said you need only show a reasonable possibility of persecution. And that, the Supreme Court has said, amounts to about 10%. So there you have information deficits that have led the Supreme Court going out of its way to help applicants for asylum. But there's a flip side of that too, that I think most immigration lawyers, all immigration lawyers know about. And that is that we are not always sure if our clients or prospective clients are telling us the truth. Every immigration lawyer finds some clients who lie. I'll give you one quick case in point that I have. This is a composite case, you need to know. Okay? I had one client who said that he was a Rwandan teenager back in the early 1990s during the Rwandan genocide, when the Tutsis were being slaughtered by the hundreds of thousands by the Hutus. He said, help me, I'm a Rwandan teenager, I'm here all alone, help me get asylum status. So we took this client everywhere, to family court, then we took him to immigration court, did the whole thing, filed an asylum application. Then we got our antenna up because someone who knew Rwanda said, I've listened to this guy speak and I'm not sure he's Rwandan. So we confronted the client. It turned out he was not Rwandan and not a teenager. Instead, he was a deserter from the Nigerian army. Now, maybe I should have caught the warning signs of that before, right? I didn't, though. And this is kind of example that can recur with any practicing immigration lawyer and can happen with officials who process asylum claims or refugee claims abroad. Information is very hard to come by. So to some extent, the concern about extreme vetting that Samantha raised earlier is a concern about making sure we get it right, which isn't easy. There are going to be false positives and false negatives. There will be errors in both directions. And getting it right is very difficult. So that's the instinct, which is not an altogether unreasonable instinct, besides saying, let's try to vet things a little bit more carefully. The way it's done here, I think, is counterproductive. But I think that's the instinct behind it, and that's a perennial issue in immigration.